The Texas Penal Code offense of abandoning or endangering child, elderly, or disabled individual includes conduct in which one of these categories of persons didn't necessarily experience harm, but the danger of harm occurring was so great the conduct is considered criminal. First, this statute identifies who the victim must be in order to charge this offense. According to the Penal Code, a child is a person 14 or younger. An elderly individual is a person 65 or older. Finally, a disabled individual includes a person with autism, a developmental disability, intellectual disability, severe emotional disturbance, traumatic brain injury, or a person who, by reason of age or physical or mental disability, defect, or injury, is unable to protect themselves from harm or to provide food, shelter, or medical care for themselves. The Penal Code states a person who, having custody, care, or control of a child, elderly, or disabled individual, commits this offense when they intentionally abandon the child or person anywhere under circumstances exposing the child or person to unreasonable risk of harm. If there was imminent danger of death, bodily injury, or physical or mental impairment, the offense is a felony of the second degree. If the person did not intend to return for the child or person, it's a felony of the third degree. If the actor intended to return for the child or person, this offense is a state jail felony. Next, an actor commits this offense when he or she intentionally, knowingly, recklessly, or with criminal negligence by act or omission engages in conduct that places the child or person in imminent danger of death, bodily injury, or physical or mental impairment. An example of this offense might include a parent or person in charge of a young or disabled child leaving them unattended at a place like an apartment complex swimming pool while the parent shoots up. Now note, in both these sets of elements, what constitutes a situation of, for instance, imminent danger of death depends upon what is reasonable to the average person. Sometimes students get confused between the elements of this offense relating to children and another offense in the Penal Code which you may have come across called leaving a child in a vehicle. The difference between that offense and abandoning or endangering a child, elderly, or disabled individual is that the offense of leaving a child in a vehicle depends on very specific time and age requirements. The offense of abandoning or endangering a child, elderly, or disabled individual only includes a child's age as an element, and in general, the imminent danger of death, bodily injury, which includes serious bodily injury, or physical or mental impairment. These must be articulated to a judge by a peace officer and or prosecutor after the fact in the courtroom. Don't confuse these two offenses. There are two specific circumstances the Penal Code identifies which are automatically presumed to fit the element of imminent danger of death, bodily injury, or physical or mental impairment. The first is if the defendant manufactured, possessed, or introduced into any person methamphetamine or a Texas Health and Safety Code Penalty Group 1B offense, which consists of fentanyl and other substances, in front of the child or person. It also includes if an analysis of the child or person's blood indicates the presence of methamphetamine or a Penalty Group 1B substance. The second is if the actor injected, ingested, inhaled, or otherwise introduced a Penalty 1 or Penalty Group 1B controlled substance in the child or person's presence. Both of these are state jail felonies. The Penal Code clarifies it is a defense to prosecution if the imminent danger was an organized athletic event and appropriate safety equipment and procedures were used. Finally, this offense doesn't apply. In other words, it is an exception to prosecution if the actor voluntarily delivered the child to an emergency infant care provider as defined under the Family Code.